Hey, you guys, this is Jeri Morgan, CEO of Code Blue Computing, and I'm super excited to have you join us today for our latest Denver Business Owners Town Hall. As you've noticed over probably the last month, 6 weeks, we've been trying to talk about issues that are of concern to business owners. And so today we're going to be talking about risky business. And I'm going to bring on our two speakers right now so that they can introduce themselves and we can go over some questions that we have as it relates to HR and liability. And so I want to introduce everyone to Joe Whitcomb and Lynda McKay that are here with us today. And what I want to do is I want to introduce each of you individually and then have you tell us a little bit about your business before we jump into some of the questions that folks have been sending out to us on these topics as it relates to HR issues and potential liability issues as we're bringing employees back in from being outside of the workplace as this whole COVID-19 situation has evolved. So first, I want to introduce Lynda McKay, and she is the owner of HR Extension. Lynda, why don't you tell us a little bit about your background and your business?
Well, I've been very active in the human resources world for over 25 years now, and have started as an HR assistant and worked to a VP, and then started my own company a few years ago. Okay. So a lot of experience, a lot of exposure, and I provide services to clients who are either not wanting to hire a full-time HR consultant, or they want someone to pair with for expertise, or basically they want me to be their HR department because they really don't need a full-time employee. So that's what I enjoy doing.
All right, awesome. Well, thank you so much for joining us today. Next, I want to introduce Joe Whitcomb, and he is the founder of Whitcomb Selinsky PC here in Denver. And Joe, why don't you tell us a little bit about you and your firm?
Thanks, Jeri. My name is Joe Whitcomb, and as Jeri mentioned, I founded Whitcomb Selinsky back in 2012. We are about 15 lawyers in the Denver, Colorado area. Similar to Lynda, we tend to serve small businesses as our sort of outside general counsel. So the sweet spot for our company is representing firms who aren't quite big enough to support their own internal legal department, have their own general counsel.
Right.
And we a lot of our work is in the government contracting space, and a lot of our clients are veteran and business owners. But as everyone, I'm sure within the sound of my voice can imagine, employment issues come up regularly, and we're having to advise those clients and sometimes defend those clients as it relates to employment-related matters.
Okay. All right. Awesome. Well, thank you so much for joining us today, Joe. As we were talking about, over the last couple of weeks, there are some potential HR and liability issues as we bring folks back in, and as business owners, it's always a good idea to do some advanced planning, to think about things that wouldn't necessarily occur to us in our day-to-day operations. So I'm going to start out with a few questions for Lynda, if I can. And these are questions that folks actually sent to me in advance, things that they're worried about. And the first question that I had for you was, from an HR perspective, are there things that we should be doing differently right now as it relates to folks coming back to work? What should we be doing in advance of that?
There's two different perspectives. There is the physical perspective of preparing the office, the restaurant, whatever it is, in preparation for employees to come back. Mm-hmm. And then there is also the mental preparation, making sure that they're well aware when they might be coming back, when they're invited to come back. Do they want to come back? I think that's a big thing right now. Some people are making those choices. Right. But you want to think about also communicating even if they're home right now. I think with any kind of disaster recovery plan, you want to make sure that whatever stage you're in, that you're definitely communicating to your employees everything that you're doing on their behalf. That's the feeling that they need to feel, that you're going to care about what you're doing. Right. If you're in an office, you're going to want to get more air in the office. You're going to want to make sure that workstations are the 6 feet apart. Make sure shared work items are either washed down or you have separate ones using for different individuals. So a lot of those things are the physical changes that you want to make sure keep your employees safe.
Right. And I know that businesses are supposed to be putting a COVID-19 workplace coordinator into place.
Yeah.
And really, what what is going to be a good choice as far as that, and what's that person really supposed to be responsible for?
Yeah. Well, typically when there's a new coordinator, something that involves employees, human resources is typically it falls upon, or the office manager or executive management, all depending on the size of the company you have.
Right.
But the biggest thing is that you want to make sure if you're going to officially have a workplace coordinator, because somebody's doing it already, they just maybe don't have that official title.
Right.
But they're going to be responsible for making sure whatever practices you're doing should be consistent. And then you also want to make sure that there's some policies and protocols so employees are aware of exactly what your expectations are of them. So it will be also important for, as they come back, who to talk to about this issue. And do they know? Is it HR? Is it this manager? Is it this supervisor? Or if you have an OSHA department or a safety department.
Right.
So it's going to be really falling on that particular individual to be managing and administrating your program consistently, because just as with any other law, if you don't be consistent and someone feels they're being treated differently, you have the risk of, a claim.
Right, exactly. Now, and the thing that I think is so interesting about this, Lynda, is generally to be able to treat people consistently. Usually, we have some time to put procedures into place and have written protocols for our business, and kind of with this shorter window.
Right.
It's hard to do, but I imagine it's even more important to try and at least get that initial written policy into place so that we know what to do, and then change that as we need to.
Absolutely. I think the first and foremost, you're going to have policies and procedures, then they can be all very formal and long and what have you. But I think in a bullet sense form, to get it going, you really need to have a communication tool, however that may be, of how they're supposed to be asking for, whether it's the time off, the concerns, and have those things. This is the process. If you need, here's how you ask for it. Here's how it will be approved. How we're going to communicate with you while you're gone. Those are the first things I think that you probably want to get in place. It's the very first thing that I started working with my clients who look to me to create those things for them.
Right. Okay. Now, so tell me, in a lot of the towns here in Colorado, we're starting to get, initially we were getting, we were strongly recommended to, be wearing the masks and the gloves. And some of the towns here in Colorado are requiring them. So as a business owner, what do we do if we have an employee that feels strongly that they shouldn't have to wear it, that they don't want to wear it? What do we do from an HR perspective with that?
Right. Well, the first thing to think of, though, is that employers have never been responsible for taking on public health responsibilities. This is the first time, at least that I can remember in my career, that has happened. So now employers have to decide what they're going to do and what they're going to provide. But let me define or separate people who can't or people who won't. And I think that's why you need to have, whether you're, your HR or workplace coordinator, that really knows how to ask the question, because someone says, well, I can't wear those. Can't versus won't. Can't could be the possibility of a disability or a medical condition that prevents them from using those items. Then you're talking about having the interactive process for the ADAA, American Disabilities Act.
Right.
If you won't do it, that's kind of a choice. That's saying, I'm personally deciding I'm not going to do that. And refusing to comply if it is part of your job requirement is kind of like any other time. If it's your job requirement, you should be prepared to take the appropriate steps to understand what they're doing. Or if you have other options, if they are strong about it, do you isolate them? Do you give that person the option to work from home continually? So it really comes into taking each situation and making sure you're addressing it so that, again, you're addressing their needs, but at the same sense being consistent throughout.
Okay. Now, so tell me, I know that a lot of people, as we head back to work, school is not back in session. A lot of summer camps have been canceled. So we may have folks that their jobs exist now, right? But for childcare or whatever reason, they're saying, I can't come back. I can't come back to work. Does that fall under some sort of, FMLA type of situation, or what do you do with that?
Absolutely. In fact, while we're talking about people coming back on this
Right.
this webinar today, or this broadcast today, the
Hmm.
truth is that there's employers that have been continually working.
Hmm.
Um, and I have those clients. So we've already been addressing those issues through the Family Friendly Corona Response Act,
Right.
which offers two different paid leaves. And the one is emergency paid sick leave, and
Hmm.
the other one is emergency FMLA family leave. So if you are in that case where you are still needing to be at home, both of those paid coverages are available for that specific reason.
Hmm.
So as you can imagine, there's a lot of different reasons why someone would not come back because they don't have the proper care. And there's very specifics about them of applying that. But yes, those are available exactly for that reason. But keep in mind, they're also not always at the exact rate you were being paid.
Right.
So FMLA is being paid at 2/3 with a maximum of 511 a day, 511 a day. So it's a lot to consider. Not all families can afford that.
Right. And then the other thing that could come up is, what if folks they don't have a child care issue, but they're just scared. They're worried about contracting the virus, and they don't want to come back in. And
Right.
your business is requiring folks to be in the office. What do you do with that?
Well, everybody has the choice.
Right.
We all have the professional choice of whether we want to do something or anything or not. So
Right.
once someone makes that decision, it is up to them. But it's already been very clear that through the laws and through the different information that's been coming out from the different departments, is that refusing to work is not, or scared of the
Mhm.
coronavirus is not an acceptable or covered in under any of the covered leaves of paid leave. So it's not, refusing to come back to legitimate work. And I think what also you need to keep in mind is that if employers have received that information from employees and they may be on the current paid leaves or
Mhm.
unemployment, there is a program that most unemployment insurance programs offer that a lot of people don't know, because normal times we've never really used them. But it's
Right.
called refusal of suitable work. And they can basically, in essence, go online and report their name and they've refused work to them, and they
Right.
may lose their unemployment.
Mm. Yeah, and it's so interesting to me, because so much of what we're navigating right now, we've never navigated anything like this, as long as I've been a business owner, and even when I had my corporate job, before. So, the employers are figuring it out, the employees are figuring it out, and it's just there's so much to consider,
Absolutely.
as we go through this process. Now, tell me, is COVID-19, is that considered a workman's comp issue?
Well, I can say maybe.
Right?
The reason why, well, first of all, yes, for federal employees, any federal employees, yes, it would be a workers' compensation issue.
Hmm.
They could claim for it. But I say maybe because when you are looking to have something covered, anytime you do have an incident, you have to put it in your OSHA tracking. But to
Right?
actually have it made as a claim where you can be covered and paid for it, it's
Hmm.
going to be very hard and very important to make sure that you have that direct link, that you have acquired this disease from your employment.
Okay.
And if the employers are doing all they can, it's going to be very hard for that to happen. I'm not saying it wouldn't ever happen. I'm just saying,
Right.
given from what the perspective is at this point.
Hmm. Well, yeah, and unless you've got a very specific incidents where you've got a lot of staff involved, it would be very hard to pinpoint
Yeah.
exactly where it did occur.
Well, especially because we do, again, have those choices to make and be around
Right.
other individuals at the grocery store, whether or not you have the gloves or you have the face mask.
Right.
Again, it'll be very hard, but you would have to have a pretty good stance on that you did
Right.
get it from work.
Okay. Awesome. All right. So I'm going to pop over because I've got some questions for Joe, kind of from a legal perspective, from a liability perspective. Now, from your perspective, Joe, are there things that we should be doing differently right now from an employer's perspective to try and alleviate potential liability issues?
I think the obvious and short answer is yes.
Right.
But I think that it will be increasingly apparent as we go through this that there will not be a one-size-fits-all solution to everything.
Right.
I think everyone on this conference goes to professional services firm.
Yeah.
With varying degrees of required contact with customers. We were fortunate as a firm, for example, to be largely able to move to a virtual space fairly seamlessly. Now,
right.
We weren't able to take care of childcare issues.
Mm-hmm.
There were things that, with schools being out and daycares being closed, there were things that we really, and we learned along the way that even daycare closures was not a universal construct. There were some daycares that were open and other daycares that were not.
Right.
Obviously, hospital workers, for example, needed some place to be able to get childcare for their children, especially if you had two members of the household who are both in a person-to-person contact industry like healthcare, for example.
Right.
Around that. You asked Lynda the question about workers' compensation, right?
Right.
One obvious example of a pretty clear workers' compensation claim would be a hospital employee who contracted it would be fairly clear, right? At least a body of evidence would demonstrate that it's more likely than not that they contracted that disease at work.
Right.
In my office, for the last, this is for humorous, but for the last 6 weeks, I've been running around in 12,000 square feet, which I've been more than about 4 of it.
Right.
Really, the odds would be low.
Mm-hmm.
I think the answer, aiming for a short answer to your question, which is, if you're in an industry where person-to-person contact is not required, and erring on the side of caution, but looking for creative ways to be able to deliver your goods and services without person-to-person contact. And again, what Lynda brought up is very true. There's a lot of personal choices being made.
Mm-hmm.
Personal choices whether to go into a grocery store or have our groceries delivered online. And in our law office, we have the ability to keep people distant. But I don't run a taekwondo studio. And if I were running a taekwondo studio, or I was running there are lots of industries, massage studio, whatever, that requires person-to-person contact. And I don't know that there is a way
Right.
to guard against the sort of person-to-person contact that that policymakers are encouraging us to do. So I don't know what the answer is universally.
Right.
We've seen, I think we've all seen, one of the things our office is going to do, and I think we've seen it in other places, putting up plexiglass barriers
Mm-hmm.
between employees and staff, certainly having masks. We have masks available for people who come in and feel more comfortable in that. We've taken half the chairs out of our space. But
Right.
I think what's clear is that we're all learning as we go.
Right.
It's largely uncharted territory. So there's a huge common sense factor here.
Right.
And I would tell you from a legal liability perspective, the litmus test in legal liability is always, the rational test, right? What would the rational business owner do?
Right.
If you met that test, you've taken precautions. I saw a news article yesterday about a restaurateur who expressly denied his employees the ability to wear masks. I think that restaurateur is inviting grief, legal grief in the future. That's an example of maybe something not to do.
Right.
They can't wear masks.
Mm-hmm.
But and again, I think I maybe went farther on that than you invited. So.
No, you're fine. And really, and that was kind of my, my question is, if an employee, contracts COVID-19, are we potentially liable for that, and I guess that's something we're gonna find out later. Of course, in healthcare situations, it's a different conversation, but in other situations, it's more complicated.
Well, we'll understand though that when let's go this clear. So if you are carrying the state requirement for workers' compensation,
Right.
that is, and excuse the pun here, but it is an inoculation against suit for injury on the job, right?
Right.
That's the reason you carry workers' compensation. Now, if you have exempt officers within your corporation, there may be a separate issue of liability there, but that would be the same liability you would owe that officer for any type of workplace injury. But again, I think Lynda hit on an important point from a litigator standpoint, attorney who litigates, trying to prove that an individual contracted a contagion work site would be extremely difficult. You would have to demonstrate that individual basically had no other human contact other than their contact at work, and we don't know. I mean, I think as more and more universal testing rolls out, we know just how far this pandemic has gone into the general population. That it may be impossible to verify where an individual contracted the virus. So I think in that instance, from a litigator standpoint,
right,
I think that liability would be difficult. Now, the liability from simply not following the rules,
right,
what we lawyers call per se liability. So there's a law that says you must wear a mask and you don't wear it. That's not per se liability; it's per se negligence.
Right.
As far as the negligence standard goes, we satisfy that by simply breaking the law. And then the damages part of any liability case, are we the ones who caused you the harm? That is a much tougher hill to climb.
Right. And what about these situations where the state and the counties and the cities are strongly recommending these masks and gloves, and you've got people that don't want to do it? Then we go back to the HR, I guess the HR side of things, where if that's our policy that that we're doing it, that it doesn't really matter if it's legally required. We're saying as a business, this is what we're going to do.
Right. As a business owner, I'll let you chime in on that.
I'm not sure what he said, but I'm going to answer that.
That's what you're saying.
Thank you. First of all, there is a public order right now in Colorado that does say certain particular essential businesses do have to have, whether it's both a mask and the gloves or just the gloves, as for those non-essential service ones. Right. And then, of course, continuing on with masks as well. But keep in mind, we already had industries that have to wear masks. I mean, biohazards or different things, whatever your job may be that's exposing you already to those things, that's going to be a requirement. No questions asked to protect yourself. So it, again, while the EEOC has released very strong recommendations of doing that, and there are in Colorado certain industries that have to do it. Right. Again, those who don't, it's a choice. But the truth is, if it's a job requirement, you really got to consider the facts of that. And if that's what they're making it so, it is still at will state to determine whether they want to keep someone who's risking other people or not.
Right. Okay. All right. That's awesome. Thank you so much for that, Lynda. So, Joe, I'm going to pop back over to you because I'm kind of curious on this this requirement of people doing the temperature checks as people come to work and doing the symptom checks. Is there a potential of overstepping the bounds of what's allowed as far as health inquiries or exams? Is that kind of a tricky area in your opinion?
Again, the short answer is yes.
Yeah.
Super tricky, super close to intersecting with HIPAA restrictions. I mean, who knows that information? Our policy in our office, we have a thermometer available. Our the policy we've issued in the office is, if you have to police yourself. If you have symptoms, do not come to work. And we don't care how you learn about this. You learn about them because you walk into a grocery store and are monitoring. But we don't have any healthcare providers who work here. Right. So I'd be really nervous about, just interpreting the results, saying that a 99-degree temperature, which can come from 1,000 different things,
Right.
is definitely COVID related. And we're trying to take a very humanitarian approach here. Like we recognize that people need work. Besides the money, people need vocational satisfaction. They need to be able to be functional. They need to be functional. So what we've told people is, look, if you're ill, don't come to work. That's a little bit reckless at this time. And if you learn you have a fever, use that as an excuse to go get tested to rule out the virus. But we are not instituting, and I think an employer would be hard pressed to force someone to take a temperature. It's different. It's distinguishable from, for example, from saying, in order for you to start work here, we all know, before you start work here, we can send you out to a lab and require you to do your analysis and drug testing. That's legal. That's not the job that you're doing and requirements for that job. It is a different thing, I think, on a day-to-day basis to make someone take their temperature before checking into work. I think it is precarious. And I think you're inviting, as an employer, you're inviting liability.
Well, it's kind of interesting. I have a friend that works in the grocery stores, and they've got what is essentially the office manager for the store that's checking people's temperatures as they come in every day. And the thing I wondered about that at the time was, okay, but you're taking this information down, but then where is this information being stored? Because then you've got the whole who has access to other people's medical information. So, I was just kind of curious. Oh, I wonder how you manage that, or even just the whole process, of making the decision to do that, right?
Well, and I know, I'm just going to say this, and what made that particular office manager or whoever's doing those temperature tests become medically able to be solid in making those decisions. Like while the EEOC is saying yes, employers can do these things, the truth is somewhere down the line, if you end up keeping someone home because you have decided they might have a temperature and they lose out on a job and their money and not be able to maintain their house or feed their children, when all this may pass, they may be very angry, and when people get angry, they make claims. Of that they were treated differently. And it's just putting employers that are not in the medical field all of a sudden in a position that they were never trained for.
Right.
Yeah, I think that to Lynda's point, we all remember after 9/11 the idea of putting armed pilots. And then we suddenly recognized the last people we didn't have using guns or people who are untrained to use weapons on an airplane, right? And I think that's it's analogous, but it's different, obviously. I'm not a doctor. I'm not medically trained. I'm not comfortable issuing diagnosis. I'm certainly not comfortable telling someone, well, now you have to go home and stay home for weeks, because that's not for someone who they might have COVID-19 symptoms, right? Is that they're supposed to stay home for 2 weeks or self-quarantine for 2 weeks. I think what I see happening, and again, I'm going to put on my policy walk hat here a little bit, is I see the government trying to impose upon employers for the government's inability or failure to be able to test universally, right? The government isn't able to test universally, so now they want to put the onus on the employer. It's an unfunded mandate. They don't have, there's a lot of questions about the constitutional authority to do some of the things they're already doing. And I don't have the power of the government. And the government isn't comfortable going as so far as stating, you must wear a mask, you must take your temperature. I certainly don't feel comfortable stepping into that position. I lack the state's police powers to do that.
Well, and even I kind of wonder about that, as some of the towns have set the mandate that that customers need to be wearing masks, and then that responsibility for policing that is supposed to fall on the businesses then. So that's just an interesting, an interesting kind of turn of events over the last week with that. Now, do you have any thoughts on that, Joe?
Well, I mean, again, from a policy perspective,
Yeah.
it seems like from a policy perspective, the government is putting, again, on employers an unfunded mandate. The
Mm-hmm.
employer is neither qualified to do medically, nor, doesn't really necessarily have the logistic support. And again, we're talking about a very, this is a forgiving environment where I work in the law.
Right.
It would be an entirely different thing if I worked at an H&R Block, or if I worked at there's a lot of different settings that you can imagine, daycares, dojos, all of these things where person-to-person contact is actually part and parcel with the job. That this would be untenable. And it's essentially a death sentence to the company. So I don't think that's working.
Right. And like I said, and we talked a little bit before we got on the call today, just about how this is such a fluid situation, that it's just, it's kind of moving and changing, every day. And that, we as business owners and folks that are, kind of the people that help the business owners do what they need to do. It's just, we just have to try and stay on top of it and do the things, that we're supposed to be doing, first of all, to keep our people safe. I mean, that's the most important thing. And all of it, from my perspective, it all comes down to the people, keeping our people safe, keeping our customers safe, doing the best thing for our businesses in general. Right.
Yeah, absolutely.
Now, Joe, do you feel that COVID-19 falls under the ADA at all?
No, that was a place where we actually spent some time doing the research.
Right.
And so the way the ADA works is it does not have an enumerated list of diseases or impairments that fall under the ADA. The test is, does it substantially, two parts, does it substantially interfere with a major life function, right? And so clearly if you have, but it also has to last a particular period of time. So certainly, and there's some intersecting laws. So if you had COVID-19 and you were one of the unfortunates that ended up in the hospital for a long time, certainly FMLA could kick in about the amount of time that you were off and whether you'd be guaranteed employment when you returned. The CARES Act, I think, brought in some enhanced sick leave requirements that could kick in. But accommodating an individual, I think, to Lynda's point, portrays fear of COVID-19 would clearly not fall under the ADA, right? I mean, fear generally. Now, if someone were, you could hypothesize about someone who had an unusual fear of whatever.
Right.
Then you might have to do of anything, right? A phobia of something. And then the question becomes, the first question to answer is, can they do the fundamental requirements of the job? And then the second question is, if they can they do it with reasonable accommodations? And what is reasonable changes from employer to employer. So what's reasonable to Costco, a multinational publicly traded company,
right,
will not be necessarily reasonable to Code Blue, which is a privately held company that's geographically limited. So, and that becomes a test of importance. So unfortunately, there is no answer. So if someone were if someone said, as an example, I need to work from home because I'm terrified of COVID, and it was reasonable to accommodate that, then I think the smart thing for an employer to do is to accommodate, right? That avoids the lawsuit in the future. But if it's simply not, again, I keep using this on purpose because one thing I can think of that it requires person-to-person contact. If you're a wrestling coach or you're a taekwondo instructor and it requires face-to-face instruction, and it's hard to imagine. I guess you could do some instruction via virtually, but those are examples where you can't do the fundamental job, the fundamental elements of the job require person-to-person contact.
Now, so tell me, as we've had folks at home for like a month, and there are a lot of businesses and a lot of business owners that I've talked to that they're making the decision. You know what? We don't have to come back in the office right now, so we're still gonna have a lot of folks working remotely from home. But from a liability perspective or from an employer perspective, are there any potential liability issues with the folks working from home, as far as, if they're, are we responsible for making sure their home workspace is set up safely or ergonomic, or if they trip while they're doing work, for us at home? Is there anything we need to think about in regard to that?
So there are two things.
Mm-hmm.
And it's a great question. So there are two things. So the real underlying question there is it theoretically feasible that your workers' compensation insurance would extend to employees' workplace at home, right? That gets really sticky, doesn't it? Because if you're sitting at let's say you're sitting at your desk and you're mousing and you get carpal tunnel syndrome.
Right.
That's covered under workers' compensation. It wouldn't really matter in that instance if you were doing it from home.
Right.
But what if in the middle of the day you're hungry and you leave your work desk upstairs,
right,
and you start ascending the stairs in your home where you work and live, where you live every day, and you take a tumble down the stairs on your way to work, on your way to your lunch? That, I think, would be analogous to someone who leaves the workplace at here and walks across my parking lot to get food in the adjacent restaurant. That would be an instance not covered by workers' compensation. If, on the other hand, I think we all know this as employers, and I know Lynda certainly knows this, if we send someone to deliver something,
right,
and they get injured on their way to deliver something, then their workers' compensation would click in. But the second part that I thought was super interesting to your question is, in that same instance, they get into a car accident and injure someone else. That's what we lawyers like to call it. Then there's vicarious liability by virtue of the employer that injured someone else because you set them on a job. They're driving their privately owned vehicle and they injure someone. So then the question goes, all right, well, if they're working at home and they have to leave their home to do a delivery and they end up injuring someone, or here's another wild one. We normally have all of our stuff delivered to our office, right? If someone slips and falls on our property, our general liability insurance would cover that slip and fall. But what happens if that same delivery person is on your employee's doorstep and they slip and fall? Right? Does the employee's homeowner's insurance cover it when the UPS person was there to deliver a computer for the job?
Right.
That's all I can tell you as a lawyer is that I haven't found an instance where that issue has been litigated, so that would be brand new for the court.
Right.
Whether or not that is an employer liability or general liability, and ultimately that would turn, in most instances, into a fight between different insurance companies. Who's going to cover the fall?
Right.
State Farm or USA, right?
I know, and it's just another one of these things that has come up as as we navigate this, and I suspect that having folks working from home, at least in the short term over the next year, there's a lot of businesses that haven't done that previously that are doing it. So I think it is, these are good things for us, us to think about, or even as so many businesses, when they had to move to remote, had to go quick, and there were a lot of folks that worked for us that we wouldn't historically had work from home, and then if it is going to be a longer term situation, it's probably a good idea to at least make sure that work situation is at least ergonomically sound, if it's going to be a longer term. Because like I said, so many of the businesses that we were helping in those first couple of weeks, it was just kind of, go and, get folks, able to work from home, get the phones over there, make it so that they could, connect, and it wasn't necessarily ideal. But as we're kind of looking at extending this, making sure that, that folks are set up in the best way, possible going forward for however long it's going to be.
No, I think that's a solid point, Jeri. Thinking about as we all did, I think we all collectively rushed to mandate this. The governor made in our state, gave us essentially a weekend.
Yeah.
To a universal stay-at-home order. I think scrambling and again, we were fortunate, again, that a lot of folks had laptops already and were already working at home, and that was great. But you can imagine a lot of the service consumers were heavily impacted by this. They were not prepared. They were not, and the ergonomics you're talking about, it's easy to enforce, good, ergonomic hygiene at the office, especially if you don't do that in someone's home. If you're going to go to their home and inspect their workplace, that's a little bit, that's a little steep.
Yeah, absolutely. I mean, and there was just a bunch of stuff with that switch, even for us kind of trying to help people from a security perspective, making sure that the ways that you're connecting from home and, the home networks that people are utilizing to connect, there was just, a whole laundry list of things that had to be done, across the board so quickly, so, it's just, people did what they had to do. But I think if it's, and I think people are pretty settled now, but still, if it's going to be a longer term situation, it's a good idea to make sure that you've got things situated longer term, and also that you've just got, if you do run into it again, like they say, we might, as we bring people back in, that this might be, something that we have to do periodically, that we're able to do it with a little bit more grace, the next time, because they're
more fluid.
Yeah.
Okay, we've done this before now.
Right. Yeah. It was just, some of the businesses, it was, they made it over the finish line there, but it, wasn't necessarily pretty.
If only barely.
Right? Yeah. So now, Joe, I have a question for you that I was really curious about. It seems that there's a lot of different guidelines when you go from the federal guidelines to the state guidelines to the county and then your city. So I'm curious, when you've got different guidelines coming from different locations, does it go to kind of like the smallest entity that you fall under to follow your guidelines, or what do you do?
So that is the response to that is unfortunately a little bit unique in that the county commissioners, so they all derive their power from something, right? So the governor obviously derives their power from the Constitution, and there has been some local, we've seen some challenges already. So we saw a challenge in California to the governor's mandate that people stay off beaches, that the litigants, in my estimation, just drew the short straw on the judge, and they quickly punted it. And I don't know, I never read that decision, so I don't know. So what you would expect to see happen, the difficulty, I think, is enforceability. So I live in Jefferson County, and I'm working in Denver. Jefferson County creates a rule that says, stay for at home, and we're going to extend the stay-at-home order until May 8th, which is tomorrow. Now, I've always been part of that, that list. Weirdly, I've always been constantly pot distributors and the alcohol stores are all part of that essential group. So I've always been able to leave, within guidelines, not more than 50% of my staff, still maintain social distancing, all of that. But what I think the unanswered question, or the unanswerable question, is what happens if a person leaves a community that has one regulation and enters a community that has, or a township or a county that has another regulation? While I'm at work, I would assume that I'm subject to Denver County Denver city and county rules on stay at home, what's allowed to be open, what isn't. And when I'm in my home, the places I'm allowed to go and patronize are actually governed by the county commissioner in Jefferson County. And I think the answer is, one, I think there's an enforceability issue. There's clearly not enough resources in Jefferson County to go around and be the thought police on who is allowed to be out of their home and who's on their way to work and who isn't on their way to work. But where I think it comes out is like anything else, is what happens if you're traveling and you're not supposed to be, and you get into a car accident. Right. Then where did you just trigger a per se liability because you were negligently away from your home, even though the county commissioner had told you to leave? So I think being jailed for that isn't as big an issue as inviting liability because you ignored the order in your particular area. But short answer to your question is, yeah, we're first responsible to its proximity. So the closer that entity is, that government order is to us, the higher our level of perceived loyalty or liability. So if the county commissioner says I got to stay at home, then I've got to stay at home. But clearly the governor of Colorado has more authority than the county commissioner. But the governor of Colorado has opted in this instance to not override.
Right.
Like we saw the President of the United States recently used his, the Defense Authorization Act to say, if we're going to meatpacking plant, you're essential, you must go to work.
Mm-hmm.
And
Yeah.
until that gets challenged in a courtroom, right, and a court overthrows that order, then that is the order, right? And so that's kind of the way that goes.
Okay. All right. Well, I want to thank you both for joining us today, and I wanted to ask each of you if there are things that we didn't cover that we should have, or just thoughts that you had that might be helpful to business owners right now. And so I'll start with Lynda. From an HR perspective, is there anything you'd like to add today?
Absolutely. The one thing I am seeing could happen is if some people who did not work at home before,
right,
now they're successfully working at home,
right,
and like it.
But
the employer wants them back in the office. I think we're going to see a cultural change in a lot of companies if they're successful in doing their jobs from a distance remotely. It's going to be a challenge if they really liked it and they're not able to do that anymore. And I have a client who will be experiencing that, and I know those employees, a lot of them like working from home. So I think it's something employers need to be prepared for.
Right.
The actual desire to continue doing it. And of course, if it's an accommodation and it works, it's a great option. But it'll be something to consider.
Yeah, and I think that's interesting. When I had my corporate job before I started my business, the culture at that company was very anti-remote working, and really the perception back then was that that folks couldn't perform at the level that you needed them to perform at when they were working remotely. And it could very well be that this will be an opportunity for employers that wouldn't have considered some of these things previously to really consider them. But I do agree that there will be instances where an employee wants to stay at home and the employer doesn't want them. And I suspect there'll be issues the other way too, where maybe an employer's like, hey, maybe I don't need to pay for this office space, and the employee's like, no. They're like me, no, working from home, no, so it'll be interesting to see kind of how that plays out.
Well, I want to piggyback on Linda's statement, and I'm actually stealing this from another law firm that I met in. So I think there might be a way to turn lemons into lemonade on that. So it's a bigger law firm. They had they were about 90 attorneys. They had kind of a relaxed remote work policy.
Right.
What they would do is they called it, I think it might be called this universal. They would do hoteling. So if you wanted a space like me or Jeri, and I want to have an opportunity to work in my office occasionally, but I don't want to be tethered to that office. I don't want to have to work there all the time. And what they would do is basically they'd have a suite mate. They would work Monday, Wednesday, Friday, and their office mate would maybe have that office on Tuesdays and Thursdays. And what that allowed that firm to do is they could actually increase the number of employees that they had without necessarily having to increase the amount of linear space that they were occupying. Right? They would have to grow. But again, I think that's a lot easier in like a professional services outfit or in a where what you're doing. It's much more difficult to do in a warehouse environment. You can imagine all the difficulties in a warehouse environment doing that. But there's one other thing I want to, since you invited the response, one other thing I want to speak to the Colorado employers about, which is the legal. Colorado has an unusual, I don't think it's unique, but has an unusual statute that relates to legal off-duty activity. So as most people know, like Colorado is quote-unquote at-will employer, which means I'm going to shut that down, guys. Sorry about that.
Like, what is happening?
So they have a legal off-duty activity. So where the cases you see that come up is in Colorado is an individual goes on a Facebook page and criticizes their employer on Facebook. The employer learns about it and fires them. Right? Well, there's been case law in Colorado. You can't do that. Right? It's legal. Even to that for employment, if that's your motivator for firing them, you're firing them for legal off-duty activity. Now, you can see that coming around. I'm sure you've both seen sort of politically charged statements from both sides of the debate on COVID, wearing masks or not wearing masks. Right. Like, imagine an employer words about their employee going into a grocery store and not wearing a mask, where it's not required that they wear it, and then feeling morally obligated to punish that employee by firing them. That, in my estimation, is inviting a lawsuit from that employee, because that is still legal off-duty activity. So the employers have to be careful how far they go in policing their employees off-duty and what they do off-duty, as far as wearing masks or going to family gatherings. Even though they might feel like that employee is being irresponsible, it's no more accepted than firing that employee for having a beer on the weekend. It's just not legal in Colorado. Now that is not true everywhere. There are some states that don't have that statute, and you can, as long as you don't cross the line on Title VII, for race or gender or any of those protected classes, right. But in Colorado, since I suspect a lot of our audience is Colorado, you cannot fire an employee for legal off-duty activity. It's not illegal. They're doing it off, and the reason for firing them is something they did when they're not at work. You're going to find yourself in trouble.
Now, is there a potential issue, if employees, when they're working from home, they feel, and that there's not really been a conversation that you're expecting them to work outside of working hours, but I know a lot of us as business owners will have ideas or shoot emails out kind of outside of your regular 9 to 5 period. If an employee's getting emails from you outside of regular hours and they're feeling compelled to answer them, or they're feeling compelled to kind of jump into that work mode, is there potential, is that a potential issue?
I'm going to get down to Lynda, because that's the
right. I'm like,
yeah, it is, but I think the issue is more of a concern when you're separating out exempt employees from non-exempt employees, which a lot of people associate. It's not always, but a lot of people associate the hourly paid versus the annually paid or paid on a salary.
Right.
Unless you have, and it is possible, unless you have a job and an organization that has the ability to have very strict constraints on what they're doing in the time that they are at home,
right,
it can be possible. Though when you're non-exempt, everything you do should be docked as being paid and on your time card. Now, if you're an exempt employee where you're paid on a salary, part of being exempt in that level is being able to do work when is needed or for how long is needed, such as during tax time. Accountants are going to work a lot longer than they're going to work in August, right? April's going to be busy, August is going to be slow. Well, that is the seasonal effect, but just taking that example is exactly how, a salaried accountant is not going to, even though they're working more hours, getting more emails, they're not going to be paid more.
Right.
Now, that could be the choice of an employer to choose maybe a bonus as a reward, but under the FLSA, so that's the biggest concern, is whether they're being paid hourly and they're classified as non-exempt, because everything you do should go in. So it is very hard. We hold our computers in our hands and our phones, and everyone works all the time. And that's great for those of us who might have our own business or are exempt, and you can get the job done. But for non-exempt, it's a very big concern.
Okay, awesome. Now, so Joe, tell me, was there anything that that we didn't hit on, or anything that you wanted to add from a legal perspective?
Yeah, from a legal perspective, I have to go back to my opening comment, which is that this falls largely under strategic limit. There's a lot of this that will be litigated in the future, and again, I don't even think I think it's premature to even predict where we are in the entire pandemic timeline, whether we're near the end, whether we expect this to come up again in the fall. I think there's a lot of stuff yet to be litigated, and I think, even the governmental policy tends to change from day to day. I got an email. Actually, I have an employee who's an attorney who's also owns a restaurant. And as the restaurateurs are, I know they're being punished. I mean, they are probably the hardest hit industry right now, because they have such high capital, they have such high overhead. But there's a lot of uncertainty that I think is driving a lot of the anxiety around being a business owner. So,
Right.
from a legal standpoint, I have to tell you that a lot of this stuff will unfortunately, I think, play out in the courts for years to come.
Yeah. With time, when there's a new law, sooner or later, there are going to be new lawsuits.
Root for lawyers when there's a new law. When the legislature gets busy, I get rich. So that's.
All right. Well, I want to thank you both. Thank you both for joining us today. And just if people have questions later, or they wanted to follow up with you each individually, Lynda, what's the best way for people to contact you?
Through my email.
Okay.
Please share my direct email.
I will.
Like everyone else, on my computer all the time.
Right. Absolutely. And Joe, what's the best way for folks to contact you?
I would say the first time is easiest by email. There's also lots of forms on our website that you can use at whitcomblawpc.com that you can reach us. But once you've reached me the first time via email, then you're going to have about 4 different phone numbers to reach me on. So.
Okay. All right, awesome. Well, I want to thank you both for joining us. It definitely made me feel better as a business owner to kind of hit on some of these topics that have really been on my mind, and I know you guys have helped a lot of other folks today as well. So we're going to go ahead and sign off now. But I do appreciate you both so much. You guys have a great day.
Take care. Thank you, Jeri.
Bye bye.